example, I think about 30 minutes to start meditation and some of these people. So, to reinforce those studies. So, let me do my best to simulate that motion. All the areas and arguments are open. On a much more serious note, I think this is one of the cases, the mandate government, which gave us an opportunity. I'm not someone who practices criminal violence, and we should not make it. So, this gave me an opportunity to understand how criminal laws be understood from the Constitution. And given that this was already a fun issue, I did my best to capture my concepts as clearly as possible so that there is relevant scope for research. So therefore I thought my written concepts and matter will be shared with the organizers, with other personnel and with personnel. Those who wish to read the written concepts just to understand the argument of the society, please take the effort to go through it. The idea is to go beyond the discussion that happens on popular forums, or popular fora, and also to perhaps avoid all misrepresentations that my position on social media derives from now, let me just read on the two paragraphs, the introductory paragraph from my exam, just so that you have a clear picture of what was said and what was not said, what was position taken and what was position not taken. How many questions do we have here? No, 5 years. And these are 5 years for 3 years for them, 5 years. How many do we 5 years for them? So, this was a 31 page written submission followed by case of violation of this. But you can make certain adaptation. This way, the first 10 or 15 pages. So, here's what was said. I appeared for the mental welfare trust. So, page 30 will be established. So, here's what I basically said on behalf of the particular. These were the prepared to do the substitutes made prior to getting to the master goals of the legal analysis. The legitimate concerns of the intervening organization cannot be brushed aside with admin accusations of patriarchy, since that has the effect of shutting down any sane and balanced discussion on an issue that will benefit from a plurality of diverse perspectives. The issue at hand does not merit an adversarial treatment, which is being the entire tone and tail of the submissions made on behalf of the petitioners. My way or highway approach on issues such as these rarely yields better and effective outcomes. The intervener herein has never been opposed to the criminalization of spousal sexual activities. Specifically, non-consensual sex between spouses or those in spousal-like relationships, namely different relationships. In fact, as shall be seen here and below, there already exists a legal penal framework for spousal sexual offences. It is certainly not the case of the intervener organization that husbands/men have the right to impose themselves on their wives/spouses, citing marriage as the legal and of consent. It is certainly the position of the intervener that trust, dignity, and respect on the basis of marriage, and that is a two-way street. That said, the issue at hand is not merely about consent, but also about context, which the petitioners refuse to see or acknowledge. The multi-layer and multi-variable nature of this equation has been reduced to the sole issue of consent, which is precisely where the petitioners and the interveners disagree. The clear and calibrated position of the intervener may be summarized above. Therefore, what is the precept? 1. So, effectively, to read the judgment, and I say both terms of this bench, the kind of pure salvation. It just so happens that I believe that still the process was incomplete, because we are looking at the issue of marriage plus constitutionality plus criminality. you need some people who are subject matter experts when it comes to marriage counseling. People who have some idea as to what happens in such cases. People who have, let's say, counseled couples on, let's say, putting together, piecing together a broken marriage. Or instances where there have been domestic violence. Unfortunately, in this case, there is absolutely no representation allowed on behalf of any subject matter expert. It was entirely left to lawyers to discuss such a issue. Treating this issue as a pure question regarding conflict, which is not. So check this. The petitions in question were filed in 2015. Guess when they were taken up for arguments of the 2022. 7 years after filing the petition. And there is a specific docket in the US called a docket docket. It's a fast track court. This particular matter was finished in 2.5 to 3 months, from Jan to March, after being taken up after 7 years of implementation. In stark contrast, when the union was saying, since this happens to be a subject matter that falls within the conflict case, we need a business experience. And there needs to be a wide consultation of a larger body of stakeholders. They have been accused of dragging this piece. So one of the questions that we asked was, the court itself seems to be taking a matter after 7 years of this trial. And seems to have concluded clearly this matter with a period of 2 months, rather at just 3 months, without having heard of the subject matter. Now that was multiple issues. One, it explains why a court of law is such a poor and inadequate court for policy formulation, because it has absolutely no space or bandwidth for input from various stakeholders. Two, there are constant comparisons being made between the P77 case or the Share case and this particular case to say, if the court can strike down the constitutionality of 66 or read down the constitutionality of a portion of section 377, why cannot it adopt a similar approach with respect to the second section, section 375? The answer is section 66A under the IT Act as it existed resulted in direct criminalization. It was not an exception to criminalization. So when you strike down or read down that particular provision, the court is not creating or expanding a certain species of offense. It is reducing criminality. Or it is taking out the criminal provision from the statute altogether. Similarly, when it comes to section 377, when it strikes down a certain portion, it reduces the scope of criminality, it doesn't widen the scope of criminality. In stark contrast, if there is an exception to an offense, the killing of that particular exception means widening the scope of criminality. And this is not an indirect consequence, that is not just a direct consequence, it is the intended consequence of the offense. Which is to say that it must be possible to prosecute a certain species of people or a certain class of people, and this particular exception comes in the way. So let us for a moment assume that on this particular issue, I seem to agree with the petitioner that yes, marital rape must be able. Let's assume that that is the case. And this is in fact the case with the petitioner, as well as the parties I have said. It still translates to a situation where a judicial body is being given the power to come up with a new class of offense, a new species of offense. Which means that the floodgates are open for this particular case. What stops the court from doing it in the future? So the first preliminary constitutional jurisdiction question that was raised was on the basis of the doctrine of direction power. Prior to moving into the legality, the constitutionality of the exception to section 375, the very first question was, let us have a discussion of doctrine of direction. What we basically said was, a situation which doesn't result in widening the scope of criminality, and a situation where the direct consequence is widening the scope of criminality, the situations cannot be compared to each other. These are two very different classes of circumstances altogether. In the former, there is no violation of doctrine of separation of powers, SOP. And therefore, there is no transgression of the line drawn by the Constitution with respect to institutional boundaries. Whereas here, the direct step in the first direction. So, to that, Vishaka was basically side of the argument. That the Supreme Court can come out with guidelines in the context of sexual harassment in the Vishaka. What stops the High Court from doing that? I think the answer lies there, which is the Supreme Court has powers under 142 and 142 which are not comparable with powers under 226 of the High Court. That's the first question. So you can have these conversations and bleeding hearts who do not want to understand the provisions of the law or in law schools, you can still arrive at the very same position as the petitioner by staying within the bounds of the Constitution without violating the boundaries of the Constitution. Or you can say the Constitution can take a head by position of the right. So therefore we basically say, please consider this. When Vishaka was being laid out by the Supreme Court, there was no law. It was a legal vacuum. Whereas when it comes to this particular exception, there is law of the conscience. It's not just a question of vacuum, there is a law of the conscience. And therefore, one, the circumstances are not comparable. And second, assuming there were, it is for the Supreme Court to take up this issue, not the High Court. So most people may not even recollect this, but during most virtual arguments, if you look at the way of it presented both by Rainbow and environment, the first argument that was presented was, keep up this matter to the Supreme Court. Let the Supreme Court look at this particular issue, because a similar issue is pending for the Karnataka High Court, a similar issue is pending for the Gujarat High Court. Therefore, take it up to the Supreme Court and let that Supreme institution make a decision on the particular matter. Now what has happened finally? You come out with a straight verdict and you still give everything to the Supreme Court. That's the reason and being safe. Now here's the interesting part before I get into the board again. Strictly speaking, a split verdict by a division bench is not a judgment. Because it's like perhaps Newton physics, where you have an equal opposite force and transfer rates. The capacity is the consequence of the judgment that means it is not decided anything. Even if it is not decided anything, provisions of the CPC clearly say that a certificate of appeal to the Supreme Court can be given only in the context of a judgment. This is not a judgment. So how do you send it to the Supreme Court? You should have sent it to the Supreme Court before coming out with the judgment. But if you come out with a split verdict, the only option as a division bench of the High Court is to refer to a larger bench within the same High Court and not to send it directly to the Supreme Court. This is why you have reference benches which are strictly constituted within High Courts. If there is a disagreement between two coordinate benches of the same sex, or between two judges of the same bench that happens to be a division bench. So, apart from the question of constitutional propriety, this is also a question of institutional propriety. As practicing lawyers, these are issues that you must take into account. These questions or these issues may not make sense to non-lawyers, but they must totally make sense to lawyers. Because you're not just looking at the facts of a particular case or the outcome of a particular case, you're asking yourself the consequences of a particular decision on institutional entity. What does it do in the future? So, in fact, we kept saying, MWT was one of the few organizations that had approached the Supreme Court a couple of years ago asking for gender-neutral laws with respect to sexual offences. That petition was returned by the Supreme Court on the ground that this is a matter for the legislature, not for the judiciary. So, MWT, an ostensibly male-dominated patriarchal organization, approached the Supreme Court for gender-neutral laws. Please show the law and please go to the legislature. Now, what is so different in the prayers made by the petitioners before High Court in the fact of this case? Why did it get a judgment? Interestingly, a similar petition was filed before the very same High Court a few years ago, having similar prayers. It was written on the very same argument and moved to the legislature. Make a representation to the relevant department of the government, don't cover the law. So, why did this particular matter get this kind of attention? When similar matters were different people before the very same High Court and Supreme Court. That's one. Now let's come to the actual question of separation of powers, and this is a technical argument. While experimentation in the heart of the society is the primary purpose of the existence of democracy, wherein you say this is the right option, you come out, and then you say the other says, no, I believe this is the option, I don't believe. An unelected body, which does not have a mandate, cannot interfere with this process, except by way of exercise of the power of judicial review. And the power of judicial review is curtailed by the doctrine of separation of powers. This is how the argument fits, or at least how the theory goes. So therefore we say, the doctrine of separation of powers is not to be treated as a de facto agreement between beggars and a sailor. This is basically to respect institutional sanctity. So the public participation is protected at the end of the day. This is not for protection of term of the legislature to take this to the judiciary or vice versa, but it takes away my right as a member of the society to participate in this particular discussion by presenting my opinion before the legislature. The court said I don't have the bandwidth to hear more than 6 or 7 parties and all interest applications are going to be preserved and dismissed. That would have happened before the legislature because the parliamentary science committee would have had to hear, the law commission would have had to hear, they had no option not to do so. Any draft legislation would have been put out to comments. At least that seems to be the new mandate after the farmer protest. The court says you speak with the parties concerned. Now, where is the discussion happening with respect to marital guilt? Why is this important? An offense is not, it does not exist in a vacuum. It creates an ecosystem. What does it create? Forum, evidentiary standards, principles, doctrines, presumptions, rebuttables, irrebuttables. Which means the existence of a provision in the IPC translates to creating handshake provisions in the CRPC and the Evidence Act. Can a court of law come out with not just an offense, but also evidentiary standards? Can a court of law come out only with an offense without speaking on evidentiary standards? It can't, because then the argument of the entire picture is incomplete. In which case, who gave you the power to come out with evidentiary standards? Now, there are presumptions with respect to sexual offences in the Evidence Act, which clearly says that in certain category of offences, the word of the victim is sufficient proof, and there is presumption of guilt. Now, those presumptions work and can be accepted provided the parties concerned are strangers to each other. Because then the question will be, अगर आप दोनों के बीच में कोई रिश्ता नहीं है, तो आप उनके घर में क्या कर रहे हैं? What are you doing with this lady at a particular point of time when you don't know each other? Therefore, it becomes easier for the victim's word to be taken much more seriously because there is no existence of prior relationship. But it happens to be a legal relationship with a history of cohabitation with the same group, or it happens to be a marriage under the same group, then what do? Am I therefore saying that there is no possibility of recognition of marriage later on? No, I'm not doing it. It will certainly be equally recognized over contracts. That is, contracts which are not documented can also be established by way of examination. So similarly, any offense that is committed in the privacy of the bedroom between the spouses can also be established. What do we then ask for? If there is no darar in the relationship otherwise, is this one of those instances that somebody went berserk and chose to impose himself on herself? Now, this is why you have to read these sentences because that is the provision that deals with commission of sexual offences between spouses. Where one of the things that the court is expected to ask is, prior to this, was there a de facto separation or a legal separation? This is to say, they may not have been separate, but when they fighting, you will ask the neighbors, did you hear noises on a regular basis in terms of people hitting each other? Where there are constant fights, which was ordered in the rest of the audience also. On that basis, you arrive at the conclusion that there is a sufficient basis to believe the wife's word or the husband's word. Now, interestingly, the petitioner wanted this to be a gender-specific categorization, whereas we said, all along we've been arguing for equality. Why don't we wish to ask for equality in the context of recognition of gender? This is possible as well. So, if it is an equal word, then you accept the possibility of offences being counted on both sides. You can't give entitlement of that particular term. You can't suddenly put on the gender carpet. Your entire argument is on the basis of equality between rape and marital rape. Then what is your problem in accepting equality with respect to a sexual offense between spouses regardless of gender? Who has decided today that both spouses will be able to do gender and be representation marriage, especially after these are being made out. And how do you decide who is the wife party or the husband party that happens to be? Let's say same-sex marriage. How do you define these? Who's the bush and who's the bottom? How do you know? Who are these questions? So we can look at the array of questions that come out of this. How can a court answer these questions? A court which has not had the time to take up this matter for 7 years, here is a period of 3 months, is going to answer all these questions. Sexual harassment was particularly in the context of domestic violence been expanded to give a better view to people. Why can't you then apply the very same logic to this question to architect? That's a precise question. Now, the next thing that you say is, I'm sorry, even if there is 376B, it doesn't call it rape, and therefore you have a problem with labeling of the offense system. So, one of the arguments raised was, it is not a new category of offense, it is merely creating a new class of offenders. So, to say rape exists, you are merely expanding the scope of the people who can be attracted or who can be prosecuted. Now, this effectively takes you to the argument of context, which is rape with an adult and rape with a minor are being as two different classes altogether because not interest also. The other doesn't. Because context makes it different. And context is either the form of a relationship or an under age barrier or mental soundness. You could be an adult technically but of unsound mind. I would then still say that the person has to be attractive. Because the person is attractive. And legally it is established in that position. So, the law is not just about defining a particular act, it also speaks of the context. So therefore we said, if context is important, there are two C's which complete this equation. It is concept plus context. You are focusing exclusively on concept, you are saying please take both into account. So one of the reasons why multiple parliamentary reports from the say that we need to be careful about this, it is not to protect the husband as a particular profession, it is not what it says. Basically it says, you are protecting the ecosystem that the couple will create within the family. This is the assume for a moment that there is a child or children that comes out of the verdict of marriage, and then you brand one of the parents as a rapist. Regardless of the fact that one of the parents is a rapist, the child suffers the consequence of being a product of a rape marriage, or a vicious marriage. So there is stigma associated with it. So you are saying, punish, warn, do all that, but also shield other parties from wrongly affected. So what happens usually is, 376B is invoked, along here you have provisions for the domestic violence which are usually invoked. And the next part is, domestic violence includes sexual violence within its ambit category. And sexual violence is not limited in sex. Which is to say, sexual violence does not say that it happens to be non-consensual sex, it is outside the scope of sexual violence. There is no such exclusion. The only argument which came from this from the other side was, no, 376 is inadequate because the punishment is not the same. Domestic violence is problematic because it's not a one-stop shop. It requires a domestic incident report to be prepared first on the basis of which recommendations are made. And those recommendations exist because you wish to also protect the institution by doing justice to the violence. Okay. Now let's go a step further. This is the question of legal research. Is inadequacy of a particular provision ground of unconstitutionality? Punishment hai, lekin kam hai. Can that become a ground of unconstitutionality? If that is the case, everybody is subject to opinion on the adequacy of a particular punishment or sentence, which is prescribed for an offense, can translate to the ground of unconstitutionality. Then why can't we see the age of 18 for majority of individuals also unconstitutional? Because I don't agree with the particular number that this discussion starts. So the point is, inadequacy is not a ground of unconstitutionality. Then the other argument was being raised was, no, the existence of the exception to section 375 is arbitrary. Now let's test out this idea of question. So something to exist, or something to be treated as arbitrary should make no sense whatsoever. It should be a random decision, not element to any kind of reasoning or examination. You can't make the argument of arbitrariness while simultaneously saying that the provision exists to protect the institution of knowledge. You acknowledge the existence of a reason, and then you can't make the argument of arbitrariness. You can only say disagree with the reason. If you disagree with the reason, that's a policy question, that's not a constitutional question. Which is to say, what you couldn't achieve through a government previously or a previous dispensation, you can't hope to achieve that through a court of law. Because then it takes away the power of the legislature to decide on these matters. So what do you do then? Okay. How do I then prove the argument further that this is actually not arbitrary, it has a sound reason for it? Because the 376B has to be read with 198B. Which speaks of presumptions, which speaks of pre-trial prior to the investigation of 376B. Then you have 376B, which speaks of only the particular exception with respect to gay, and you have other provisions, 376C, so on and so forth, where other categories are recognized where people in a particular position of power are also accused under certain circumstances. So, which means it is possible to draw a very clear map on the categorization of sexual offences by strangers, by people with whom you have a relationship where there is a dominant power equation, with people who happen to be your spouses, with people who happen to be minors. Which means even within classification of sexual offences, the IPC recognizes a rainbow. Not the other rainbow, I'm just saying multiple colors. So I am trying to make the argument here that when there is an internal ecosystem or there is a logic within the IPC, how do you then claim that this is arbitrary? That means the intelligible criteria for the purposes of satisfaction of Article 14 is evident here. That there is a reason why this particular provision exists. Then multiple arguments are effectively cited to the extent Nepal has come out with sexual offence or the definition of marital rape to the court. Not a single court has done this in any jurisdiction. Every court has basically said this is for the legislature to do. And those instances where marital rape has been recognized, whether it's UK or several states of the United States, the degree of evidence and the standard of evidence is higher. Presumptions are higher. All those examples are presented. So you couldn't present an example to basically show that it's possible for a court of law to do this. And second, we are clearly showing that the existing presumptions, if applied as well, will lead to a lot more mischief. Because the Supreme Court has already said that 498 has been subjected to a lot of abuse already. In such a situation, you want the recognition of marital rape by a court without addressing questions of evidentiary standards. So there is already a complicated crucible. You must say solve other four more games. Makes no sense whatsoever. So the final argument was no. In the context of the independent thought judgment, the court has clearly said that the state has no legitimate interest in protecting the institution of marriage. And therefore, that can't form the basis for the existence of any exception whatsoever. Three important points to be noted here. Please read the independent thought judgment, the independent of what I say. It starts off by clearly saying that this is limited to the question of marriage of a minor and the consequence on the corresponding provision of POCSO. See, POCSO evidently treats this as rape of a minor, whereas there are other provisions which say the contrary. How can this kind of a mismatch be allowed to exist? This incongruence has to be addressed. So that is the context. And at least in three places the Supreme Court goes on to say none of the observations made in this judgment have been cited in the context of marriage and rape between parents. Because we are not ending in the particular question, that is not the relevant of the examination, that is not the subject of the examination. In light of this, so what is the position? Have I now created multiple arguments for non-resolution of marital rape? No. I am saying please go ahead and recognize it, but let it not be the judicial work that does it. Let it come to the route of the judicial legislature. And out of all the petitions filed before the Supreme Court and all the players made before the Supreme Court there was only one player which was decent. We said, direct the legislature to take up this matter policy paralysis and the legislature is playing very on this particular issue, the judiciary can say, take a decision. Let people know what your mind is and do it in a time-bound manner. No problem. But the judiciary cannot say, आप इस नतीजे पे ऐसे पहुंचेंगे. You can neither direct the course of the inquiry nor the outcome of the inquiry. That is once more a transmission of SOP. That's not possible for you to do. Tomorrow can the legislature or the executive say, you know what, there are 4 crore cases pending across the board and I don't think the judiciary is doing a great job of it. So let me start interfering in the process of judicial examination and say, इसको ऐसे रखा कीजिए, इसको ऐसे मत कीजिए, and the legislature start doing. Of course they start. Because usually independence of judiciary is under attack. Intellectual integrity has to be maintained, conflict morality has to be preserved. Everything else will come. Why is institutional independence on such matters not protected by the judiciary with respect to other acts? You have the power of judicial review, but even the power of judicial review is to be used in certain instances. When it comes to foreign policy, you can't see. When it comes to defense, you can't see. When it comes to taxation, you can't see, because this is beyond the scope of your expertise and your knowledge. Similarly, when it comes to social policy, this is not something that you can do. First step for an institution which is interested in preserving and regaining the confidence of the public is for it to stay within the boundaries stated in the Constitution for everyone. So the doctrine of separation of powers and the quantification of respect to constitutional morality is reserved for other organs of the state must equally apply to the judiciary. And the judiciary is not an exception to this. In this slide, please go to the written submissions as well as go through the opinion of Justice Shankar, which supports Ms. Nandini's position, the opinion of Justice Shankar, which in some ways supports my position. Remember, one thing, I have not made a single argument on the basis of Bharati Samaj. I have not made a single argument saying, oh, what will happen to our Sanskrit? It has been recognized. I made no such argument before, nor am I making it. These are plain and simple constitutional arguments without bringing culture into the picture. Now I bring culture into the picture. One of the arguments made before the court was that the provision as it exists is a colonial provision, so it needs to go. Plus, it does not enjoy the presumption of constitutionality because it is pre-constitution. People who see Article 31 and Article 32, which effectively speaks of a handshake between pre-constitutional laws and post-constitutional laws and preserves them as a bridge. Unless it violates public policy in some way, which means until a particular provision is struck down, the presumption of constitutionality that inures to post-constitutional laws equally applies to pre-constitutional. So the argument is invalid. Now it is surprising on the one hand, you think this is British position, so let's get away with it, let's do away with it. And on the other hand, international norms and standards are being cited on a regular basis. America has done this, UK has done, why not? The entire argument of why should we do it just because online is doing it. Now you think, why should we not do it because UK and America are doing it? So we say, in matters of social policy, public morality is a definition that goes through a municipal freedom. Which means every country reserves for it the right as to what is public morality according to its own culture. And that is precisely what it will manifest in form of social input from society. You can't shut the doors on those inputs by saying let the court do it and let nobody else do it. So my limited argument from a scientific perspective is allow people to participate in the solicitation, deliberation and arbitration. You may ultimately come to the conclusion that this is a species of offense that needs to be recognized. In which case it's still for the legislature to do so. It has to be gender neutral hopefully, and you're looking at creation of evidence standards as well as presumptions, VIPC, whatever. This is all understood as far as the issue is concerned. Nobody wants to make light of a legitimate body issue. Nobody wants to make light of a sensitive concern. It is easy to dismiss such arguments as smokescreens being presented to create impediments in the way of management. That is not the case. So please understand these issues in a manner that law researchers and law students are expected to. for a moment keep your passion aside and just focus on what the argument is being presented. You can still disagree with it. No problem. I'm not saying everything is bulletproof. But at the very least, let the discussion happen on these lines. There must be some difference in manner in which lawyers discuss these topics and activists discuss these topics. Thank you.
Hi.
Yes.
Great point for Sai Deepak. I am Teen Moorti Bhawan Foundation, Bangalore. So I'm not a lawyer, I'm an activist on the other side of the problem. So I would like your comments on two different social and legal background contexts, the elephant in the room. We have been in this field for more than 20 years, and we have seen that in 20 years, judiciary of the legal apparatus has blatantly promoted anti-adversarial matrimonial situations. We as activists will claim 100% resolution. This is one part. Okay, agree or disagree. The other background is 19th March 2013. The sexual assault and sexual harassment laws were overhauled. Lot of change happened. There was long overdue. Fine. Happened. Lot of debate happened. Lot of protests. So Parliament was passing the amendment in the evening, and just a couple of minutes before the bill is passed, our MP Lalu Prasad Yadav stood up in the front row and he said, "Misuse ka kya hoga?" And our honorable Home Minister at that time, Sushil Singh, said, "Misuse hai to article IPC 219." It's straightforward, sir. Misuse hai to IPC 219. So this is the other side. Now, my problem between what happened with the Delhi High Court is that can a judge make a very sweet mistake? Because judges have the power to use IPC 219. I don't have power. Which provision of which law is not misused? Okay, this is very, very disturbing because I do not belong to fraternity, I belong to the society. So I will then think, I can go back to a lot of other philosophies to address this, because I am not getting easily addressed.
So, here's the thing. Even the best crafted provision, or most tightly drafted provision, is capable of misuse. Why do we exist? We exist for that only, That's what the lawyers do. The point is actually misunderstood when these kind of questions are raised, which is foreseeable mischief needs to be plugged by a provision. Which means whatever is within the scope of reasonable conception that this kind of wit is capable of mischief. The very same arguments which are being raised with respect to section 124A, which is for sedition, to say provision itna broad hai to kya hoga? Will they agree with the argument then with respect to sedition when I say which provision is not misused? Can I make the very same argument and get away with it? No. That would be an anti-free speech argument, that would be an illiberal argument to make. So it's, I would say, selective application of standards where they say sedition must be tightly drafted, but when it comes to this, why do you fear women using this or misusing this? That is the kind of question being raised in court. Which is to say, why do you approach this provision with this kind of suspicion? Are bhai, even if you draft it in a gender-neutral fashion, it is capable of misuse by anyone regardless of the gender. So why do you make this a gender-specific accusation? So when arguments are made to pander to the gallery, what do? आप भैंस के सामने बीन बजा रहे हैं. Which is, I'm not talking about the forum, of course, please don't get me wrong. I'm basically saying we are trying to engage to find a common ground. In fact, one of the statements we made was, we are not against you when it comes to the central issue, but there are certain legitimate concerns. The best part of the judgment, in terms of validation and vindication of our concerns, comes from Justice Shakdar's judgment where he says, I agree that if these existing presumptions were not to be plugged, then in the context of a marriage, it's easier for these presumptions to be misused. And therefore these presumptions cannot be made available in the context of marital rape, is something that Justice Shakdar says. Well, it's a great conclusion, Our point is, how can a court say that a particular presumption will not apply in the context of a certain species that does not exist in the statute book yet? Look at the institutional violation here. If an issue results in changing the status quo with respect to institutional boundaries, then you have changed the entire window altogether for the future, and what is to say that the very same issue cannot be applied in the future for whatever reason it may be. So every judge can decide ultimately, I believe that this particular issue is a burning issue, so let me change the rules of interpretation a bit, let me change the rules of constitutional morality a bit. What? I mean, that's it, then the slippery slope is effectively started. The gradient is not like this, it's like this. So I agree with you. It is the job of the judiciary as well as the legislature to look for safeguards as much as possible. 66A was dismissed and struck down on the very same grounds. Why wasn't the court open to the argument, "Arey, kis provision mein abuse nahi hota hai"? Could you have raised it? No. So you see the hypocrisy and the double standards in the approach to free speech related issues and gender related issues. You've effectively pitted genders against each other. And for you, one person coming from a particular gender is a perpetual victim and someone is a perpetual villain. This approach is bad. This approach is terrible because it has very little reason, it has a lot of heat and no light. At least be cognizant of the fact that you may have no attachment to the institution of the family, others may still want some kind of protection for the institution of the family. So how do you strike a balance? Nobody is saying at the altar of the family, let one person effectively give up her right to dignity and consent. No, that's not the argument being made. Can you find a balance? Is there a way to strike a balance? That is the question. And when that question is raised before a court of law, even if you want to treat this as non-adversarial, it has become adversarial. Because there are petitioners and respondents and each of us is attached to our own positions. Surprisingly in this case, two amici are appointed by the court. Both of them have a position which is favorable to the petitioners. They are entitled to say so. I am happy they said so because they were honest in their positions. I have no problems with it whatsoever. I have the greatest of respect for both amici here, and one of them I seriously look up to. However, what the Supreme Court has done in the past in similar matters is then appoint amici representing opposite points of view so that there is some kind of balancing of perspectives. That means 5 petitioners, 2 amici, then out of the bench, one member has a particular position. So who represents this position? Interveners and nobody else? Because the union doesn't want to take a certain position for whatever reason. So it's interveners who are defending this particular issue. So where is the representation of amici from this particular side? You want examples? I'll give you an example. In the Sabarimala case on the constitution, when it was being argued before the constitution bench, Sri Raju Ramachandran was appointed as the amici for the side of the petitioners from Ms. Indra Jaising's side. And from this side, Justice Ramasubramanian was appointed. Not Ramasubramanian, Ramamurthy was appointed. So both presented their respective legal positions without being attached to the party's positions. We're saying balance it out. In my written submission, I make the specific point. I said this during the course of the arguments that interventions are not allowed. There is no amici from this side. We seem to be in such great hurry to finish hearing this particular matter after having woken up from a deep slumber of 7 years, wo 7 saal. How is this even fair? Next. Please let the lady ask a question, then you come. There's a mic behind you. Just for the sake of my understanding, at least give me the year of your program. I don't need names, it's okay. 3 years or 5-year program? Oh, good.
I have 2 questions for you. The first one being that the argument of the petitioner was that there is a colonial provision to which you argue that there was Indianization of the ICC. If you could explain how the ICC has been used.
Okay, so one of the things that I pointed out was, more than saying Indianization of the IPC, so let her ask the second question, it's okay, let there be a follow-up, that's fine. So the point I said was Indianization of the provision, because this particular provision and whether marital rape is to be recognized or not was being considered by Justice J.S. Verma's report as part of the very same discussions in the backdrop of the horrendous incident, the Nirbhaya incident. And there is another report where there are specific observations situations that there are family related concerns here. Not one person says the wife is the property of the husband, therefore let's protect the husband. Nobody says any of those statements. And therefore, at this stage, we may not be ready for it yet. I am not going to make that argument in 2022 or 2023 that no, the society is not ready for it. No, the society seems to be ready for all sorts of horrendous things. Why not something important? No problem. I hope everybody is over 18 here. Anybody under 18? Please raise your hand. If yes, please walk out of the room because I'm going to make a very sensitive statement. A very sensitive statement, and I hope that as students who have crossed the age barrier when it comes to these subjects, who have learned biology, allow me to say some things. Oh, you're under 18? Okay, thank you. I made the argument, and I don't wish to offend sentiments here, but we seem to watch all sorts of things on Netflix, so I'm allowed to make this statement. We basically said, in the age of sexual revolution and liberation, how do you not know whether an injury is caused by passion and by belligerence? How do you make the argument that a certain bruise or an injury is the product of not the heat of the moment but anger? And how are you going to protect these provisions and these situations from a situation? Assume for a moment a couple actually has a fetish for this. What do you do then? So like Sheldon Cooper, we are supposed to draft relationship agreements. Step 1, step 2, step 3, step 4. और worse, प्रत्यक्ष प्रमाण के लिए एक साक्षी को हमें बिठा दो. Or worse, CCTV. Internet karma forever. Think about it. I'm not making this issues here. Think about this. What are you asking people to do? Look at the evidentiary standards required here. Okay, then the argument can be, is it your case that every rape that happens otherwise which is not marital rape has an eyewitness? No, not the argument. Then you say, at the very least the question is, in दोनों के बीच में कोई रिश्ता था ही नहीं, so what was this man doing there? Has he been following her? Has he been stalking her? Has he been sending her messages? Are these questions never asked during the course of cross-examination in a rape case? Did you know this person? Did you know that person? Has he made an advance in the past? If he had no excuse to be there and he has no alibi to show he was somewhere else, then the presumptions against the accused significantly. How do you prove any of these things in the confines of the marriage and home? Which is why you ask, has there been a repeated instance of beating here? Is the child able to say, my father has always been doing this to my mother? She comes out bruised or whatever it may be. Children who live in troubled marriages are capable of saying this because they are forced to become mature than other children. Because they see a lot of things that they are not supposed to at that particular age. So sometimes, unfortunately, the child is put in the witness box. There are in-camera questions that are asked. What do you do if there is no child? This is within 7 years of the marriage, and the couple lives alone because you are looking at nuclear families. What do you do then? Genuine, legitimate questions, which clearly shows that there is scope for abuse, but can they be balanced out? Next question, please. Go ahead. One, perhaps understand the fact that just as it is wrong for a man to treat a woman as the object of desire or chattel, it is equally problematic if you treat every man as a potential rapist. You don't make those arguments. I don't see how you are hoping to achieve common ground. It only vitiates an already vitiated atmosphere. At the very least, you look at some kind of common ground where there is, you see, if we are the problem, at least make us part of the solution. If you are not the problem, then treat us as allies. Either ways, it makes no sense to keep us out of the discussion. Now, we were being told that there are certain male organizations that supported the position of the petitioners. We are not against you. We are on the means, not on the end goal. We are on the nuance of the end goal, not the achievement of the end goal. So, strictly speaking, what is the delta or the gap between the two parties? Forum kaun sa hoga, standards kaun se honge, bas. And ye gender neutral hoga ya nahi hoga. Where is the discussion otherwise? You can hold me and you can actually roast me over hot coals if you believe that I'm saying something which I have not said before. The best part is, so here's what happened. I don't mind even if it's recorded. This is anyway the hearings were watched online. The point is, I specifically appeared on behalf of interveners, namely Sri Bharat Gupta, who is one of the finest exponents of two subjects, Natya Shastra in this country and how we view marital relationships and sexual relationships under Indian philosophy. Specifically saying, how is a wife to be treated? What are the restrictions on a husband's behavior? Not on how much he can beat her, no such things. Okay? Then Dr. Madhukeshwar, who's been writing in Manushi in favor of feminism but through an Indian perspective. That intervention was disallowed. MWT, the party that I represented, did not have a council. And therefore they were not getting enough of, let's say, a hearing in terms of the time that they wanted to present their arguments, because you see, if you don't have a council, not that you don't have the right to submit, but usually courts don't take parties seriously if they don't, if they're not represented by black courts. Unfortunate reality of the situation, despite access to justice being the constant mantra. And so they barely got 15 minutes or 20 minutes to argue. And so, fortunately, it so happens that on the day that I appeared, they did not have a council and my party or my intervener was disallowed. By evening, they basically said, "Sir, aap hamare appear ho jaiye." So finally, I had to go and tell the court the next day, the court has performed the role of Amazon, demand has met supply. And therefore, I have the right to argue now because there's already an accepted intervener. Allow me to present arguments on their behalf. So we had to find ways and means of having a shot at being heard. Whereas 7 of the people had already argued against. From the perspective of Audi Altarem Partem, is this fair? Ask. I'm not answering the question. You answer the question yourself. At the end of it, of course, I was heard. But assume for a moment that this hadn't happened and there was no MWT or I hadn't participated, either they would have got 15 minutes or I wouldn't have been heard. That's the end of the matter. In the process, it would seem as if everybody who's participated in the process had only one opinion, there was no dissenting opinion, there was consensus. So all you get is a unanimous decision. Sometimes a dissenting verdict is the product of a party pushing and saying, I need to present this submission because there are serious objections here. That's how you got the 4-1 verdict in Sabrimala, and that's how you got the split verdict here as well. My point is, the judicial forum is not as, I would say, amenable to equal representation of positions as people make it out to be. Next. Yes, ma'am. Go ahead. Right. Correct. Correct. Just a second. On the sexual liberation aspect and Sheldon Cooper aspect, please feel free to quote because I made the very same argument before the court. I pointed this example out from Big Bang Theory. Go ahead. Right. allow me to present my disagreement on the last point you made. Despite 498A, I'm not saying that let's not recognize marital rape. I do believe that in certain instances, maybe you may even have an argument to say a conventional rape victim, I'm sorry, I'm not trying to be insensitive here, can go to a police station directly and register an FIR. Whereas in this case, there seems to be the need for some kind of safeguards. From a victim's perspective, those may seem like roadblocks. Okay, those may seem like roadblocks. But one of the things, and that I think Dr. Madhukeshwar also said, is assume for a moment that you live in an abusive relationship. Before it moves to the point of sexual abuse, one of the first things that you do is to raise the red flag quickly for two reasons. So that the authorities know that you're living in an abusive relationship and the husband is warned before it goes to the next heinous step. Okay? Usually, assume for a moment you are silent for any number of years and then suddenly you make this argument. Again, I'm not saying you can't be trusted, but you see even in other jurisdictions what they're specifically saying is, in UK practice jurisdictions and other places, if there is a significant gap between the reportage of the event and the incident itself, to that extent, the allegation is treated as having lesser persuasiveness. Those jurisdictions which the petitioners themselves were citing in their favor were saying the very same thing in terms of practice detections. That's one. Okay. Now, the impact of recognition of this on the family unit. That question, as a non-subject matter expert, all I can say is, I don't think any kind of abuse can be defended in the name of protection of the institution. My argument has been only of balance. But the larger question that I think you're asking me and you're pushing me to answering is whether do you see this as a concerted attack on the Indian family system and civilizational values. That would require me to make a few comments on the players involved and the actors involved in this entire picture. I don't wish to. All I would say is, the tentacles are not within India. And there has been some kind of a concerted attempt to loosen the family structure of the Indian society. Now, whether this petition is an example of that or not, I am not going to comment on it. I am not going to comment on it. That's not my place. But this too is happening. Time magazine seems to have a lot of interest in doing this. And it seems to be choosing people as its ambassadors for this particular purpose. Just randomly saying, I'm not naming anyone in particular. Two, perhaps you may want to go through the list of petitioners and ask, what is the track record of each of these petitioners? One of the things that Dr. Madhukeshwar said in her intervention petition, and she wanted to actually make this argument in person, is the court does not know or is not aware of how NGOs are used to penetrate the Indian society. And as someone who has done or has contributed and committed her life entirely to this, very few people can challenge her on facts, including the money tree, where it's coming from. So ideally, one of the persons who should have been invited here for this event is Dr. Madhukeshwar. She would have blasted the gates open on this particular subject and she would have given you facts and figures. And you wouldn't have any response except for either belief or utter disbelief, because your established worldview would have been broken completely. You wouldn't have any response whatsoever in any case. When those figures and statistics were shared with me, I basically said, you know what, coming from a lawyer, this may not make too much of sense. Perhaps you should present this in court, and I'll try and get that particular audience for you, but that intervention was disallowed. Otherwise, it is a reality that certain sections of the civil society are pressed into service for certain goals to be achieved with respect to the centrality of the family system in the Indian civilization. That is a reality. I've said it, yes, that is the case. Now, whether that is the case with the petitioners in this matter, I don't know, I can't comment because I have not done that research. Next. That's it. Thank you. Thank you.